Good afternoon.
We are now in court.
Thank you. My name is Mr. Imran Nauth from ULaws LLP, and I'm representing the claimant in this matter, Claire Ashley, trading as Ashley Antiques. And may I equally introduce my colleague of the defendant, Mrs. Chandler from Billings and Co. Solicitors, who is representing the defendant, David Walsh, trading as Walsh's Emporium in this matter. Master, have you received a copy of the bundle that has been filed?
I have, thank you.
Okay. Master, my submission to this court is regarding a claim for misrepresentation. Would you like me to summarize the facts?
Please proceed with the application.
Thank you. The claimant seeks a summary judgment on the basis that the defendant has no real prospect of successfully defending the claim at trial, and there is no other compelling reason why the case should be disposed of at a trial. Master, today I shall be looking forward to deal with three matters here in your presence. Firstly, did the defendant induce the claimant into entering the agreement by his representation, and was there reliance on his conduct and actions? Secondly, did the defendant make that representation by way of express term, or was it an implied term? And thirdly, was that representation to enter the agreement made on false pretense? Turning to the first issue, Master, on the matter of present representation, witness statement of Claire. May I refer you to the witness statement of Claire Ashley, which is on page 10, 11, and 12 of the bundle, please.
Thank you.
At paragraph 4 on page 11, Master, on the 2nd of October, the claimant received a telephone from the defendant, and he introduced himself as he recently a proprietor of the recently opened Walsh's Emporium. At paragraph 5 of the same page, he asked if she was interested in buying oil and canvas portraits by Joanna Meyer. And at paragraph 7 of the same page, they arranged to meet, and he produced the portraits, and he says, "Here are the Meyers." She again admitted that she did not know much about the Austrian artists. From time to time, she would reiterate this point. And then he said, he confirmed that they are the portraits of Joanna Meyer. He made it clear to her that he is an expert in this field. And she recalled him saying that he attended several forum and symposiums and places where he was gaining substantial knowledge. He mentioned the fascinating seminar on how to authenticate Austrian portraits. And Master, at paragraph 8 of the same page, she specifically asked him if the portraits were genuine, and that she was relying on him. So here the reliance, Master. He said, "They are the best Meyers I have ever seen yet." He showed her that the portraits were engraved in the underneath at the bottom of the portraits, where he pointed to the engravers of JM, meaning Joanna Meyer, Master. How does that relate to this issue and correlating between him and his action and the claimant? The defendant claimed that they were authentic. He boasted about his knowledge of authenticity, and he was from the industry. He's an expert. He attended seminars and events. As a result, the claimant relied on his representation. Then, Master, on the first matter, as it relates to representation, the claimant has discharged his burden. The defendant has no risk prospect of successfully defending the matter, and there is no compelling reason why this matter should be disposed of at a trial. I shall now like to turn you to the second issue, Master. Did the defendant make that representation by way of express term, or was it an implied term? Master, may I refer you to page 13 of the bundle? The document entitled CA1, lot number 22. Here it reads, lot number 20, 3 19th century oil and canvas portraits dating from the Joanna era. Now, on this catalog here, this was an impress term made by the defendant to the claimant. Master, after the defendant's sent the catalog. He then sent an invoice, invoicing her for 200,000. May I take you to page 14 of that bundle, Master? On that invoice, dated 16th of October, it says, 3 Joanna Meyer oil and canvas portraits as per lot 2022 auction catalog, 200,000. Master, we can see from this catalog, as well as the invoice, the word 3 Joanna Meyer oil on canvas portraits are specifically mentioned there. Was this an express term in the catalog and the invoice? Of course, when we analyze this, we'll realize, Master, I submitted this code at the defendant's own evidence in his catalog, and his invoice would support this notion of express terms. There's no speculations nor ambiguity in relation to this matter. Master, on this second matter, the claimant has discharged his burden. The defendant has no real prospect of successfully defending this claim at trial, and there is no compelling reason why this matter should be disposed of at the trial. Master, if I may, I shall like to turn your attention to the third and final issue. Was the representation by the defendant to enter the agreement false? Master, may I now refer you to the Fellow of the Society of Fine Arts Auctioneers and Valuers document, which is on page 15 of the bundle, entitled CA3. Yes. So at the beginning of this letter, it says, "Thank you for your instructions to inspect oil and canvas portraits attributed to Joanna Meyer." Here he is specific as to the item we're dealing with. He also confirms, the report confirms that the second paragraph, they are also stamped with the letter JM. Joanna Meyer. He said in the third paragraph, "However, I regret to inform you that the portraits are not the work of Joanna Meyer." Towards the end of that document, Master, he says, the report says, I would place this total value at between 20,000, 25,000 for the whole lot. Master, according to this report, the defendant made a false representation regarding the portraits. The defendant is in breach of this agreement and must indemnify the claimant for the damages and the loss incurred. The defendant's solicitors, Master, will be seeking to establish that the claimant should be aware of the principle of caveat emptor. Of course, Master, this is a principle that is very important when you're buying something of this nature. But the simple answer here to the defendant's claim, should they bring forward, is she intermittently expressed her lack of knowledge of the matter of Joanna Meyer, as she's only started these collections a year ago. She sought to reaffirm with the defendant that they are indeed, portraits are genuine. She unequivocally expresses her fear and worry regarding the legitimacy of this portrait, Master. Towards this end, what did the defendant do after all this assurance to her that they were genuine portraits belonging to Joanna Meyer and they are value for money, and his expertise and standing and will guarantee that they are as described? Master, after all these expertise and assurance and guarantees, the defendant has produced a legal document by way of catalog and invoice while knowingly making a false representation on these documents. I caution this court to be wary of this point. The defendant does this all in the name of unjust enrichment and proceeds of crimes. Master, on this matter here, the claimant on this third matter, the claimant has discharged its burden, and there is no compelling. The defendant has no real prospect of successfully defending this matter, and there is no compelling reason why this matter should be disposed of at a trial. Master, to conclude on this issue, the defendant did induce the claimant into entering this agreement by his representation on several occasions, especially when she requested him to confirm details on several occasions. The defendant did make the representation by way of express terms and implied terms throughout his dealings with the claimant, as we have seen from the documents of the invoice and the catalog. The defendant's representation to enter the agreement was done on false pretense, even though he claimed to be an expert player in the area of arts. Master, in light of all my submission, I have presented to this court today. I can assure you that the defendant has no real prospect of successfully defending this claim, and there is no compelling reason why this matter should be disposed of at a trial. Master, you will be familiar with the provision of CPR 24 2A and 2B. These gives you the power and towards summary judgment for the claimant as a matter of your discretion if you satisfy that the claimant has discharged his burden of showing that the defendant has no real prospect of successfully defending this claim, and there is no compelling reason for the case to be disposed of at a trial. Master, I submit that the claimant has discharged his burden to this court. The claimant has shown a chronological order that were specific representations in her witness statements, express terminologies in the catalog listing and the invoice. Master, the documentation presented for your consideration clearly.
Submissions. You're coming to the end of your submissions.
3 more lines. Master, the documentation presented for your consideration clearly confirms these facts, and nowhere in the witness statements nor any of the other documents were there any substantiated evidence that the claimant did not honor her side of the deal, nor have the claimant breached any of the matters discussed here today. Therefore, the court should grant my application, award summary judgment. Master, accordingly, I ask you to enter summary judgment for the damages to be assessed. Unless I can help you further, those are my submissions.
Thank you, Mr. Nauth. Ms. Chandler.
Good afternoon.